day, distinguished viewers. My name is Olatide Arowolo, a 300-level law student of Olabisi Onabanjo University and an undergraduate intern at HARLEM Solicitors. Today, I'll be enlightening you on the concept of lawful interception of private communication in Nigeria. In this video lecture, you will be enlightened on what lawful interception means and in what circumstances would your private communication be intercepted. To start with, lawful interception means to legally stop, divert, deflect, record, disclose your private communications, which includes your text, your chat, and your messages. There are various enactments in Nigeria that regulate the lawful interception of private communication. We have the ground norm, the Constitution of the Federal Republic of Nigeria, 1999, as amended. We have the lawful interception of communications regulation of 2019. We have the Cybercrime Prevention and Prevention Act of 2015. Do you know that as a subscriber of a network service provider, your communication can be disclosed, it can be collected, it can be recorded? Even though we have Section 37 of the Constitution of the Federal Republic of Nigeria, which states that every citizen of Nigeria has a right to private and family life, and we have Regulation 5 of the Lawful Interception of Communications Regulation of 2019, which says that it shall constitute an offense and it is unlawful to intercept any communication. But we know that to every general rule there are always exceptions. Section 45 of the Constitution of the Federal Republic of Nigeria now states that Section 37, 38, 39, 40 and 41 will be rendered invalid where there is a reasonable justiciable law in a diplomatic society for the interest of the public. And also we have Regulation 4 of the Lawful Interception of Communications Regulation of 2019, which says that there shall be lawful interception by an authorized agency listed in Regulation 12 sub 1 of the Lawful Interception of Communications Regulation of 2019, which includes the National Security Advisor, the State Security Service. Moving forward, to what extent and in what circumstances would your private communication be intercepted? We have the Section 39 of the Cybercrime Prevention and Prevention Act of 2015, which states that the courts will order a service provider to intercept, disclose, and record a communication where it is upon reasonable ground to suspect the data content of such information, or will order a law enforcement officer to disclose and record such communication with the application of the technical means. Moving forward, your communication can be intercepted with or without warrant. We have Regulation 8 of the Lawful Interception of Communications Regulation of 2019, which states the instances where your communication will be intercepted. It states 1, where a party to the communication gives consent to such interception, provided that there is an incontrovertible proof of such consent. 2, where a party to the communication gives consent to such interception, provided that it is upon reasonable reason to believe that there is a threat to life and property. 3, where it is in the ordinary course of such business to intercept such communication. Now, we'll be moving to situations in which your private communications cannot be intercepted without warrants. 1, where it is in the interest of national security. 2, where it is to prohibit and investigate a criminal offense. 3, where it is to prevent and safeguard the economy of Nigeria. 4, where it is to prevent emergency in the public. 5, where it is to give effect to international mutual assistance agreement in which Nigeria is a party. Section 40 sub 3 of the Lawful Interception of the Cybercrime Prevention and Prevention Act of 2015 states that where a service provider fails to comply with the provision of Section 39 and Section 40 of this act, such service provider will be liable to a fine of no more than 10 million, and its directors and managers will be liable to a fine of no more than 7 million or 3 years imprisonment. Moving forward, Regulation 6 of the Lawful Interception of Communications Regulation of 2019 states that where a communication has been retrieved and has been admitted by the court as evidence, the authorized agency is to destroy every copy of such communication. However, where it is during investigation, it can be archived for a period of 3 years. Moving forward, I believe that with all these enactments, communication can be regulated in Nigeria and can be intercepted, and in the same vein would not infringe on the citizen rights to private and family life. To gain more information on this, visit our website at www.harlemsolicitors.com. Thank you.